We've got some fresh new young talent doing some things that I know you haven't heard before.
1, 2, 3, listen.
Welcome to Finances, your home for all things financial, investment, money and lifestyle. Hosted and curated by the very talented team of certified financial planners, Burke, Britton Financial Partners. We've been talking a lot recently with clients, and it's come up a lot internally around the importance of estate planning. We've had a couple of estate planning solicitors on the podcast with Howard Andrews and also Aspire Lawyers, and that's got us thinking a little bit more about explaining in very simple terms the importance of executors and powers of attorney and why they're important, who they're important to,
and how different they are. Again, I think there's just a bit of factual confirmation about what the difference is and when they come into play.
All right, so this is hopefully an accompanying podcast, a shorter accompanying podcast to some of the more detailed ones, but let's go on. Let's start with the executors, Ben. So what's an executor? Why is it important? Go for it.
The executor role is, again, a lot of people may have heard of it, but they're not really sure exactly how it functions. But basically, when someone creates their will of what they want to happen after their passing, the executor's there to sort of guide that process and to make sure that the assets that are captured in the will are distributed where they're meant to go to the beneficiary. So the sort of the layers of the will. Most people just think of a will as the beneficiaries, but they forget about who actually organises and ensures that it is enacted and played out as per that person's wishes.
And this is all assuming that people, first of all, have will. So we're assuming that people have understand the importance of... Someone's just fallen over outside.
That'll be right.
Well, hopefully they've got their executors in place. Having executors. Now, executors, generally speaking, are a trusted person. They are...
Well, they should be.
They should be.
I suppose one of the key points about the executor is making sure it's the correct person. So one of the important parts of that role is they don't have to accept it, do they?
That was interesting. We talked with the solicitors the other day at Aspire about the fact that it's common that people don't even know they're an executor. That probably brings us to the importance of making sure that those people, well, first of all, having a will. Second of all, thinking about who your executor would be. It might be, again, a trusted person. We want it to be a trusted person. We see it's generally family members, kids, trusted sibling or something, or parents even. But the importance of making sure that they know that they are the executor, but also have an appreciation of what someone's wishes are and the plans for it.
What are they executing? Like, what are they actually doing in that role? What are they going to be doing? A lot of people don't know what they're even doing until maybe months, weeks after the passing of that person.
And I think what goes unspoken about and unknown is just how important it can be from a planning point of view of understanding what people have, understanding where it potentially is going to go. There's so many implications from an ownership point of view, from a tax point of view, protection point of view, of actually understanding beforehand, having prior awareness about what is actually going to go on with someone's estate. So not only communicating with them about them being an executor, but what are my plans, where's it going to go, and are there going to be any implications that I need to be aware of and take care of in that role?
You don't want to give that role to someone who doesn't want it either. Like, I think we'll talk about it in a minute around powers of attorney where they have to accept that role. I think the executor needs to accept that role, know that that's what they're being asked to do, and accept responsibility for playing their part if that time comes. So some people that you might think would be great at it simply don't want to do it. Some people don't have anyone who fits that brief either, which we did talk to the ladies from Aspire about, because unfortunately there's people that just don't have someone they can lean on and trust for those roles, and that's where a solicitor can jump in and also act in that regard for them as well.
And the other thing was having multiple people, because you can have multiple people as executors, but multiple people that
can sit in a room together and hold a civilised conversation for a start.
Yeah, they need to get along. They all need to be on the same page in terms of what the expectations are of the person that's written the will. And unfortunately, all too commonly, that is not the case. People have executors that have deceased, kids and siblings that don't get along, or executors that don't know their executor and have no idea what the plan with their assets, with those assets would be.
I think transparency of what, again, we're talking about those assets or liabilities or interests that those people have and what they're wanting them to do. Having an open conversation with the executor and with that person's planner, accountant, solicitor being ahead of the curve. Again, it's not always an enjoyable conversation. A lot of people avoid it because of the morbid nature of it. But being open with it helps that executor execute your will in line with what your wishes were. And ultimately, that's why you make a will. If you didn't care, you wouldn't make one. You just were just did not have any care factor for what you're leaving or what mess you're leaving behind. Not many people, even if they may be a bit flippant about it, genuinely are that disinterested in what happens to their assets.
Yeah. And that communication, if at worst, and I've said this multiple times to clients, and if clients are listening to this, you'll have heard me say this, like at worst, it provides a line of communication between your executors and the people that they're going to speak to. So if one of our clients dies, someone's going to ring us and talk to us about the assets that we assist managing, whether it be superannuation or family trust assets or shares or property, whatever we've helped clients with, we're going to get a phone call from someone. Having already had an introduction with that person before their parents or their loved one is deceased is so much more important and also so beneficial. Just the introduction and knowing who to go to. But second to that, which is probably the main point, is actually understanding what the implications of those assets, what are some of the implications of actually potentially receiving those assets. What we know is that sometimes the executors, if they're adult children, might also be the beneficiaries and might have some of their own implications of receiving an inheritance and needing to know what to do with that. Sometimes it gets a little bit, I think maybe the reason beneficiaries who are executors, maybe adult kids, are reluctant to talk to their parents about is it feels like they're talking to their parents about, what you're going to give me or what you're going to leave me. And it's not really about that. Like, it's not really about you trying to protect what you're going to receive. It's just about having awareness so you can make better decisions. And hopefully, if your parents, they live long, fruitful lives and they leave nothing for you. They spend it all.
And that's the aim for everyone. I think generationally we're noticing a difference in that approach to the transparency between generations as well. Like, so those clients that we might have now who are in their 90s and going into aged care, and this probably rolls into more the power of attorney side of things. I have a few clients at the moment, their parents into their 90s and needing to go into care, their children, maybe two of them in a couple of circumstances or one in another, is acting as their financial power of attorney, so essentially being able to make decisions on their behalf to benefit them and their interests. They don't actually know what they've got to make decisions on because their parent has been such a closed book, which, personal opinion, I think is a generational thing, that generation very guarded about their financial interests and their assets that they do hold. Unfortunately, it creates a lot of headaches for the family members or their executors, their powers of attorney who are acting for them to try and work out what is best for them when they don't even know what they're managing.
Yeah, it's interesting because you can, for all intents and purposes, you can act as that person for all things of a financial nature, yet you've got blindness, you have the inability to actually see what they've got. We talked in our last podcast about like a stock take, the importance, and this was, I suppose, relevant to this discussion about making sure that people, as you're collating assets, you've got a stock take of what you've actually got. And when you do have those conversations with your kids, whether they're executors or powers of attorney, not just kids, but executors, powers of attorney, whoever they may be, there's a clear reference to what you've got. Most of the time, if you're seeking support from a professional accountant, financial advisor that are doing their job, they will help you put together that structure, that stock take. So it's very clear for your executors, powers of attorney, what you've got, and that then leads into good planning around what you'll do when you take that responsibility as a financial power of attorney.
And my thoughts on that being, if you trust them enough to hand over the power to make a decision on it, then you probably should trust them enough to tell them what you've got in advance of them taking the reins. Like you're giving them that responsibility, then you obviously trust that person greatly. And if you don't, maybe don't make them that, don't give them that duty and power, that you should probably trust them to disclose what you do have and how you've structured it and give them context to what maybe even your wishes are, because it helps.
Interesting. I had an email this morning, obviously not talking about clients specifically, but we mentioned before that executors don't necessarily need to be advised that they're executors, but powers of attorney have to acknowledge that they've accepted their role as attorney. But this power of attorney of a client who was an adult child had forgotten that they were. They'd actually forgotten they were because they've had the conversations haven't been regular around their parent's circumstance. So wasn't aware, didn't remember that they were actually power of attorney. So that probably speaks to why it's so important to revisit this reasonably regularly and make sure that everyone's on the same page, that the right people are in the right places, and that you update that sort of stock take of what you've got and tell the people that are going to be involved what you've got. And that includes your accountants, your solicitor, and your financial advisor. All the parties are going to be involved, including executors and powers of attorney, and the person who's writing the will or the powers of attorney need to be on the same page to make sure that the plan is implemented as per their wishes.
And that doesn't need to be war and peace. It just needs to be, like, I'm happy just to have a coffee with them. It's a pretty informal meet and greet, but you put a face to the name and you know where they're located, how to contact them. And then, maybe there needs to be some formality that follows that, but it's just a really good start just to at least have that conversation and put everyone on the same page and know who you're talking to about what you're talking about.
Yeah.
That can be a massive help. I know for a lot of my clients, hopefully, I've met their kids, their executors, powers of attorney many times over. Hopefully I don't have to have they don't have to implement their roles and we don't have to deal with their parents or loved ones situation soon, but they know where I am. They know who I am. They know where we are as a business. And they're pretty comfortable with that, how that situation sits. And, when that time comes, it will be a natural relationship that will just take over and go from there.
Yeah. One of the questions that we ask a lot of recent time, the last few years, because we know the importance of this, is who your executors and powers of attorney are. So we know who they are and who we might be communicating with. The other one, which I think one of our staff members raised the other day, is asking our clients whether or not they know if they themselves are an executor or a power of attorney for someone else. Because again, the implications of that, not only understanding your responsibility, but understanding whether or not, like, what kind of impact that might have on your own circumstances. So I'd just say for anyone out there listening, whether you're thinking about your own situation, your own executors and powers of attorney, or you are potentially an executor or power of attorney for someone else, make sure that all parties are on the same page. Make sure you've made an introduction of the people that need to be aware of what's going on.
It's not really a problem till it's a problem, as we often say. And this is probably the biggest example of where that plays out.
Correct. Yeah. Anything else on that, Ben?
I think that's enough sort of death and incapacity chat for the day. I know it's a part of life, and again, people struggle to talk about it. We get that. And again, we're not some, cold person that just sits in the corner and talks about this all the time, but we understand. And unfortunately, we've had to help people where they haven't had plans in place, or they weren't aware of what their plans meant for their other generations. So again, without going down the whole strategy path, there's sometimes where grandparents will skip their funds going to their kids to go straight to the grandkids to protect their children, to make sure they don't compromise their age pension or their blended family situation, etc., etc. And we could talk about that for a week, but it's never simple.
No, it's not, but it's a lot easier if you've got a plan in place and everyone knows what's going on. So, all right, well done, Ben. We'll see you next week.
Thanks, Joe.
We hope you enjoyed today's episode. If you're keen to understand more about how financial advice could benefit you, follow us on Instagram, Facebook, and Twitter at Burke Britton FP, or Google Burke Britton Financial Partners. Check out our client reviews, testimonials, and make a time to meet one of our certified financial planners by clicking Book Now on our website. Thanks for listening.
Any information contained in this podcast is of a general nature only. No account was taken as to the objectives, financial situation, or needs of any particular person. Therefore, before making any decision, listeners should consider the appropriateness of any information with regard to their particular objective, financial situation, needs, and seek independent advice from a licensed professional specific to their circumstances.
All right, hit it.
That translates to, don't be a moron and act on what some random person says on a podcast. Take personal responsibility. Do your homework. Ask questions and speak to an actual human that knows what they're talking about before you do anything. PB Financial Solutions Proprietary Limited, trading as Burke Britton Financial Partners, are authorised representatives of AMP Financial Planning Limited, AFS licence number 232706.